Yes.
May I have your lordships kind leave to mention
Hmm.
one inclusion of one appeal, mandamus appeal.
Fresh matter.
My
Yes.
Lord,
Immediately it will be listed.
so hearing matter.
Hearing matter.
Hearing matter. Pensionary benefit matter.
Is it running in the monthly list?
No. For inclusion. That is why I have prayed for inclusion of the matter.
See the file. Original side or appellate side?
Appellate side. Grateful to your lordship.
My lord, similar prayer, my lord, for inclusion group 6 service.
Group 6, yes. Yes, madam.
Lordship, under compelling circumstances, Lordship, I am mentioning one matter pertaining to the determination of Honorable Justice Kant, Lordship. I am appearing for the petitioners, 180 petitioners of Bhatpara municipality who are not getting their pension since
What do you want?
Lordship, kindly assigns this matter before any other bench. Very urgent, Lordship.
Unless and until the matter is released, on the administrative side, I will not be able to do. You make a request next week to the Honorable Judge once more. Let us see.
Lordship,
It's a hearing matter.
Lordship, no, not hearing. It's in the motion stage, Lordship.
You make a request to the Honorable Judge next week. Let us see what happens. Okay.
Lordship, grateful, Lordship.
Yes. Please call.
Original sir, Delhi statute number 1.
Lord, I am appearing in this case. But Lordship, inter-court appeal, my lord, there was a delay of 235 days, my lord.
Lordship, I am filing my opposition in this case. On this similar facts, your lordship, in BD plywood, my lord have not delayed their condone is not delayed, my lord.
Well, it's an intra-court appeal, my lord, regarding approval, my lord. 148, whether it is Chief Commissioner or Principal Chief Commissioner. So, my lord, the learned trial single judge said, my lord, quashed the entire proceeding and said that from the stage irregularity you have to come forward. But while doing the, my lord, he has not considered the judgment of Giriraj Commercial. My lord, I have mailed that judgment. My lord, similar facts, everything is same, my lord. Same judge has, my lord, allowed the appeal.
But what were you doing for close to a year? And the matter was remanded.
Yes.
There is a delay of
235 days.
235
days. Yes, Lord. There was delay, Lord.
Please come.
Lord,
this is an intra-court appeal filed with the Income Tax Department challenging the correctness of the order dated 11th May 2023 in WPO 947 of 2023. In the said petition, the respondent herein had challenged the order passed under Section 148 capital A within bracket D of the Income Tax Act 1961 within bracket the Act dated 21st April 2022 for the assessment year 2018-19, raising a question of law relating to the jurisdiction of the assessing officer concerned in passing this said order, as the formalities required to be complied with regard to obtaining approval of the specified authority mentioned in section 151 within bracket 2i's of the Act was not followed. The learned single bench found that the mandate under the law having not been followed did not quash the entire proceedings, but quashed the proceedings up to the stage where irregularity had been committed and permitted the appellant department to proceed further in accordance with law from the stage of such irregularity. It is not clear as to why the department has challenged this order, the impugned order, by way of this intra-court appeal. Apart from that, there is a delay of 235 days in filing the appeal. We have perused the affidavit filed in support of the application seeking condonation of delay, and we find that there is no acceptable reason except that the file was being transmitted from one officer to another. In more or less identical circumstances, in APOT 127 of 2025, this court, by order dated 25th April 2025, refused to condone the delay of 234 days in filing the appeal. As was done in the said matter, the learned senior standing counsel for the appellant placed reliance on the decision of the learned single bench in Giriraj Commercial Private Limited versus Union of India and others, WPO 1122 of 2023 dated 12th July 2023. the court took into consideration the said decision and held that the factual position in the said case was entirely different. At this juncture, we quote the relevant paragraphs of the said judgment order dated 25th April 2025. Sir, in page 2, I will mark with pen the sentence starting the revenue till page 3. Therefore, no grounds have been made out to interfere. For all the above reasons, GA number 1 of 2025 is dismissed, and the as well as APOT 25 of 2025. One line you add, there's a delay of so and so day. The respondent assessee has filed their affidavit in opposition, objecting to the delay, objecting to the prayer for condemnation. Next,
Deeply obliged, Your Lordship.
notice, sir.
I am led by Mr. Darpala. We have filed the affidavit service. Lordship direction was to intimate by mail. Mail intimation also given.
Mail intimation was given by the assessing officer.
But the tribunal says there was no exempt income. Where is the question of applying 14A Rule 8D? You come to, oh, that is one of the issues. Where are your grounds? Page number 5. You can take one more. You take, you serve fresh notice.
This is second time. First time we have served. Second time served by the AO to the assessee by mail. And
The delay may be controlled.
All right. We have heard Mr. Dutt and Mr. Bhattacharjee, learned senior standing counsels for the appellant department. 2 notices were served on the respondent assessee, but none appears for the respondent. There is a delay of 288 days in filing the appeal. We have perused the affidavit filed in support of the prayer for condemnation of delay. Though the explanation is not fully satisfactory, considering the fact that the appeal has been filed under Section 260 capital A of the Income Tax Act 1961, where the court is required to consider as to whether any substantial question of law or laws arise for consideration. We are persuaded to exercise discretion in favor of the appellant department and condone the delay. Accordingly, GA2 of 2025 is allowed, and the delay, GA1 of 2025 is allowed, and the delay in filing the appeal is condoned. Next.
In this matter, I have instruction to appear on behalf of the assessee. Bhakalatnama has not yet been filed.
No, there's a
We
delay
will
of,
say that you took notice.
there was a
Delay
delay of
99 days.
99 days.
Heard Mr. Prithvi Doria, Mr. Bhomik, Sanjay Bhomik, learned advocate, who accepts notice for the respondent assessee and submits that the Vakalatnama will be filed during the course of the day. No.
2-3 days time.
Within this week. There is a delay of 99 days in filing the appeal. As the delay has been properly explained, the same is condoned. Application in GA1 of 2025 is allowed.
May it please, Lord.
Yes, sir.
The last occasion, my lord had directed to serve through mail, which we did, the fresh service. And it comes back with an endorsement that item delivered to the assessor. There's a delay of 249 days, my lord, in preparing this.
Okay. This is an appeal filed by the Income Tax Department challenging the order passed by the Income Tax Appellate Tribunal, B Bench, Kolkata, in ITA number 43/K1/2021 for the assessment year 2009-10 dated 8th February 2024. There is a delay of 249 days in filing the appeal. Notice has been served on the assessee, and the second notice through email has also been delivered.
Yes.
Fresh service, not mail.
Notice has been served on the assessee, and it is shown that the notice has been delivered on 25/2025. However, none appears for the respondent assessee. Considering the explanation offered, which is found to be acceptable, the delay in filing the appeal is condoned. Application in GA1 of 2025 is allowed.
I'm grateful, man. Well, the endorsement of this notice may be kept in the record.
All right. The acknowledgement of. All right. The appellant department is directed to file the affidavit of service during the course of the day.
My lord. I'm grateful, man.
Milord, this matter, Milord, I would not like to, Milord, shout too much on this. Fine. হবে হয়ে গেল আর জানি তো দিল্লি কোন হয়ে আছে ভেরি টেপ
But basically, share capital was received from sister company out of FD, premature withdrawal of FDs.
So CITA has
CITA elaborately discussed and granted relief, and tribunal also. And the shares were issued at par, my lord.
All right, sir. They have filed a paper book, everything CITA. This appeal by the revenue filed under section 260 capital A of the Income Tax Act 1961. Within bracket, the act is directed against the order dated 21st December 2023 passed by the Income Tax Appellate Tribunal, C Bench, Kolkata, within bracket tribunal in ITA number 1508/KOL/2019 for the assessment year 2012-30. The revenue has raised the following substantial questions of law for consideration. Page number 6, para 13Y 1, 2, 3, 7. We have heard so and so. The department, Income Tax Department, filed the appeal before the learned tribunal challenging the order passed by the Commission of Income Tax within bracket appeals, Kolkata 17 within bracket CITA dated 29/3/2019, by which the appellate authority set aside appellate authority allowed the assessee's appeal and set aside the addition made by the assessing officer by assessment order dated 30/3/2015 under section 143 within bracket 3 of the Act. We have elaborately heard the learned counsels for the parties and carefully perused the materials placed on record. At the outset, it needs to be pointed out that the CITA, while allowing the assessee's appeal, has elaborately discussed the factual position apart from noting the various decisions in support of the conclusion arrived at by the CITA. The tribunal on its part re-examined the factual position and concurred with the CITA. The in several paragraphs, the learned tribunal has examined the factual position and held that it is not a case of any accommodation entry provider where the cash credits received are immediately transferred to other private limited companies by way of making investment in their equity or giving loans and advances. Furthermore, the tribunal on facts found that the alleged sum received during the year is from a group concern of the assessee, and it also noted the names of the directors of both the companies. And with regard to the source of the funds, the tribunal found that they were received mainly from premature withdrawal of fixed deposits during the financial year 2011-12. That apart, there was an opening balance of unsecured loans from BHILLAI Holdings Private Limited received by the assessee in the earlier years at rupees 6.54 crores, and this balance was transferred to share application money. Therefore, it was held that the sum of rupees 6.54 crores, which has been credited on account of share application money during the year, has actually been received in the preceding year as unsecured loans. There are other discussion on the factual issues. Apart from that, the learned tribunal has also noted the various decisions of the coordinate bench of the tribunal, which had examined more or less similar facts and circumstances. The decision of the High Court of Bombay in the case of Commissioner of Income Tax versus Gangan Deep Infrastructure Private Limited, 2017 80 taxman.com 272 within bracket Bombay was also noted, where the facts were identical. Furthermore, the learned tribunal also took note of the decision of this court in the case of Principal CIT versus Sri Leathers, reported in 2022 448 ITR 332 within bracket Calcutta. Thus, we are of the considered view that no question of law, much less substantial question of law, arises for consideration in this appeal. Accordingly, the appeal fails dismissed. Next.
Item number 6, I'm only asking for a day's accommodation, Your Lordship, not too well. Next week, but tomorrow also, if my lord may be convenient.
Not tomorrow.
My lord.
Senior has to appear.
I'm appearing.
Next week.
Wednesday, my lord.
All Wednesday. Next.
I'm grateful, Your Lord.
Sure.
Your Lordship, I'm praying for a short passover in this matter. My learned senior is on legs, Your Lordship.
You can't start and then.
I'll try, Your Lordship. I'm not formally briefed in the matter, but I'll try. I do have some.
You start.
Lordship.
How long your senior is likely to be held up?
He should be another 5 minutes, 10 minutes.
Then
Your
you start.
Lordship.
Very small matter, my lord, the individual assessee, but only the question, my lord, before lordship, my lord, he has not participated properly in CIT appeal. The tribunal recorded that, my lord, 18 occasions matter came up.
18 occasions.
18 occasions matter came up in the list. 14 occasions they have taken time. and they have filed one reported one submission by your affidavit. After considering that, the tribunal passed order. If anything have the SSC have anything that can be placed before the tribunal, because my responsible submission before lordship, the factual aspect cannot be
but tribunal, it was a ex parte order.
yes,
Lordship.
tribunal ex parte
What
order.
about CIT appeal?
CIT appeal, that also ex parte.
Why? What happened?
Lordship, there were reasons cited therein. Because of certain discrepancies here and there, we couldn't appear. In either event, that's not something we're complaining about. We're complaining about the final outcome here. And
But I don't mind if the
also
matter
there was
go
just
to the tribunal for fresh adjudication. I don't mind because in
It
the
can
fact,
go back to CIT appeals.
maybe Milord.
if
Because, see, one thing is, we'll have to condone your conduct.
Lordship.
And for which we have to substitute some reasons and say that non-appearance for 14 hearings was justified, which will be very difficult for the court to make such an observation.
That is Milord, paragraph number 2 of the Milord tribunal's order. You should kindly see. On the fourth line, thereafter it has been listed 18 occasions. Out of 4 occasions, bench did not function. At different stage, different counsel appeared. First, such and such appeared. Thereafter, pleaded no instruction. The tribunal has again fresh issue notice. Then such and such appeared. And shortly adjournment on behalf of the SSC, power of attorney in behalf of such and such is available in record. When this matter was listed on such and such appeared and requested adjournment, we have apprised him that matter has been lingered for a long time and the bench is not inclined. In that situation, my submission, if the SSC have any document, but that has not been placed before the adjudicating authority, fact-finding authority.
Lordship, we did furnish our documents. We furnished all the documents.
Please, show us from your memo of appeal or somewhere,
Lordship.
what was the reason for your client changing 4 advocates, not appearing for 14?
Lordship, there was in fact an issue. From the little instruction that I have from my clients, there was a bit of an issue with the advocates itself. There was issues with
And,
appearance. Suppose
then
they
if you bank upon that, there are good chances that
Your Lordship, that's one of the
that
reasons we
client may
didn't
make
really press on
allegation
those
against you.
points.
Client may make allegation against you.
Lordship,
He has made
agreed.
allegations against 4 sets of lawyers.
Agreed, Your
Nothing will
Lordship.
prevent him from making allegation against you.
That
So
is-
don't toe that line.
That is why, Lordship, we
He
didn't
may
press
tell so
upon
many
that.
cock and bull stories. You cannot be believing that. You show from record that what prevented the SSC from pursuing the matter for 14 occasions. 18 times listed, 4 occasions bench did not assemble, 14 occasions he didn't. In your pleading, you please show.
That is nothing appearing in the stay petition.
Lordship,
That
that's
should
what
have been your first ground.
Lordship, that's what I'm saying. We're not pressing upon that point because we cannot blindly believe what the client says about other advocates, Your Lordship. That's why we didn't press upon that point. However, we are substantially satisfied by the documents that we have furnished, be it the transaction notes, the bank statements that we've rendered. We're satisfied with that. We're not pressing upon the ex parte orders, really. We're not aggrieved by the fact that it was passed ex parte. Even if we are, Your Lordship, we're not pressing upon that point as much. We're only going behind the final outcome of the order from the ITAT, because of which the present appeal has been preferred.
Now let us see your submissions before the tribunal.
Lordship.
Page 193. Internal page 8 of the tribunal's order.
At internal page 5, Milord, the...
Oh, 1 second.
Page 100, 180.
Now, who are the three other associates? Ravindra Sangai, Vimalesh Kumar Singh, and Pavilion Commercial. Page 197, you take. It's in ground number 16. Got it?
Lordship.
It is further submitted that the script was not part of the report considered by the Honorable Calcutta High Court in the case of Swati Bajaj.
Lordship.
On the contrary, this Honorable Court has allowed the assessee's appeal in relation. Oh, there are three different assessees.
Lordship. Your Lordship, this is given by way of citation. They meant to only refer to these cases, that these cases involve the same script.
Same script, but
Lordship.
it was allowed.
That is my case, Your Lordship.
But one thing was, Bhattacharya, they had produced initially notice 147. They filed a return. They said, treat my old return. That assessing officer did not accept. Even in that letter, they wanted the reasons for reopening. Then subsequently, as per the direction of AO, he filed a fresh return. He uploaded the fresh return. Once again, sought for reasons for reopening. Reasons were given from which they found it was only a cut paste of the investigation report.
Lordship.
So their allegation is that independently, of course, in the report, the name of the assessee features as one of the beneficiaries. If they produce documents to show how they have acquired these scripts, that the AO should have analyzed. Not
their case is that the AO independently did not apply his mind. That is their case. But I find from the CIT order, it has been detailed order to this regard. But if anything SSC have, he has to participate in the proceeding. I am not making argument before the Lordship.
And one more thing, in case of three other assessees concerning the very same script, the tribunal has allowed the case.
Lordship.
Then it cannot be construed as a penny stock. Probably whether you have filed an appeal.
In fact, Your Lordship, Annexure K.
SSC came before Lordship, that has to be placed before the tribunal by appearing.
Lordship, but Lordship, I do agree with my learned friend. However, Your Lordship, in Annexure K, which would be at page 164, Your Lordship.
1 second.
Family member of the present assessee. Family members. Similar script, in fact, the same script.
No, before that.
Favorable order in favor of the assessee.
That you please show which will be the relevant page or paragraph from the assessment order.
Lordship.
Because it's a very big order.
Lordship.
And he has referred to what is penny stock, what is this, what is that.
If Your Lordship permits, I should just probably take Your Lordship through the facts.
Order of the learned tribunal. Learned tribunal.
186.
Give me pages. May I? That is internal page 4. Internal page 4 of the learned tribunal orders. The factual observation of the assessing officer which raised as under. But here, my lord, the tribunal, here is that the assessee has not filed any contract notes evidencing sale of shares, nor any received acknowledgement payment of purchase price of Kamdhenu Commercial Private Limited.
You will first leave then answer. Ready?
The tribunal what about argumenটের বাঁধগুলো এসেছিল না সেদিন আজকে বইপুরের ওটা তো 550 থেকে এগুলো না 150 কত হচ্ছে normal way.
See, though the assessing officer's order is such an elaborate order, only in 5 pages he has discussed the facts. You please take page 57. Para 4, Roman 4. He sets out all those things and he says 5 lines from the top, 5 or 6th line, for which no details had been filed. But according to the assessee, they have filed all the details, including the purchase was made through account payee check, amalgamation was approved by the High Court, sale proceeds required account payee check, copy of demat account, bank statement, contract note, balance sheet were submitted. Then the next finding is at page 62. Roman 7. It may be seen that the assessee could not adduce any additional evidence to refute the finding of the show cause notice. So and so, so and so. Then Supreme Court decision. 65. 3 paragraphs. Para 12, 13, and 15. The remaining are all and 70 is the conclusion. But if they have produced all those documents, and what is important is in respect to the same script, 3 other assessees were successful. But the problem is your client, conduct of your client. 18 times, 14 times he didn't appear.
That is wrong.
And your friend said that he made some allegations against those advocates. So it may not be very long for them to make allegations against both of you as well.
But may I only submit this? I tender unconditional apologies for not being.
No. That
But may I only indicate this?
We asked you.
Lordship. Milord,
it can go back.
May I only indicate one, Milord, factual aspect? Milord, since the original investment, Milord, I wanted to start, Milord, from paragraph 8 of the tribunal's order, which is, Milord, under challenge. The reason is, Milord, they have accepted, if your Lordship kindly takes up, Milord, page 197.
Yes.
Since we did not appear, my lord, it was the records and the assistance of the DR. With the assistance of the DR, we have gone through the records carefully. Perusal of the written submission would reveal that the SSC had challenged the reopening of the assessment, and this is also one of the fold of grievances placed in ground 1. The first angle, my lord, submission is borrowed satisfaction, which is not valid. In support of the contention, he has relied on the judgment of Shub Infrastructure and Harikishan Sundarlal. We do not find, but this is the observation, we do not find any force in this submission of the SSC because the assessing officer has not blindly relied upon the investigation report specifically recorded through the report on page this. The name appears in list of beneficiaries. That's what the finding is. You know, kindly see paragraph 10, which is the most important, my lord, of the findings. A perusal of the assessment. This is the paragraph where he discusses the facts in a nutshell. He says, a perusal of the assessment order would reveal that the SSC has originally purchased 300 number of shares of Heritage Windtrade from Kamdhenu Commercial at 200 per share off market for a purchase consideration of 60,000 rupees. Thereafter, shares of Heritage was amalgamated with Multiplus Resources as a part of a scheme of merger. I pause here for a moment. But had this been a private transaction, this
angle of doubt could have been raised by the department. This is not a private transaction. What is on record, what is admitted by the tribunal, is that you had purchased 300 shares of Heritage for 200 rupees per share. You have invested 60,000 rupees. Then there's a merger. And this amalgamation is an order of the court by which the share prices have increased. So, my lord, it is not our doing. It is not something that we could, my lord, foresee, or my lord, we could have done. But then he says the SSC obtained 6,000 shares of Multiplus in lieu of shares of the merged company and sold these 6,000 shares in December 2011 for 10,76,000. In other words, share purchase in 2009 for 60,000 is sold in December 2011 for 10,76,000. Roughly 2 years. Phenomenal increase in value of shares.
Are you carrying those 3 orders of the 3 SSCs? Which
Milord, we have, Milord, at page 164 is, Milord, the entire family members, but this is, Milord, which the order which is in our favor by the tribunal, not challenged by the tribunal. At page 164, Milord.
Milord, may I just one. Now, page 164, the preliminary issue before the tribunal, you will kindly see page 166. The issue was there was no incredible materials.
156.3 was an issue, Milord.
It is not an issue that, Milord, the Milord, internal page 3 of the Milord order, paragraph number 3. And thereafter, Milord, page 174, the tribunal hence now only issue which is left to be addressed is the preliminary issue of whether the addition could be framed under section 153A of the Act in respect of a concluded proceedings without existing incremental material found in course of the search. Milord, that is.
May I only indicate, perhaps that's not completely correct, because page 168, Milord, the last part of paragraph 5, the learned is, Milord, page 168. Milord, the learned AO, however, did not heed the contentions of the SSC and proceeded to frame the assessments under 153A by disallowing long-term capital gains of 12 lakhs or an addition of towards short-term capital gain due to disallowance of development charges in this. So it was LTCG which was an issue. But the additional documents which were incriminating documents, whether it fell under, Milord, the scope.
It did not deal with the script of this multiplex.
Yes, exact scripts it did not. That was not the.
Yes.
But in the grounds of appeal, what have you said regarding non-appearance? There should be something, no? Because the tribunal proceeded based on your submissions.
Documents given.
That you need to raise a ground.
Milord, there is, Milord. May I only
kindly
give me a moment, Milord. It's mainly on the merits because, Milord, the distinguishing factor with, Milord, Swati Bajaj is, Milord, the amalgamation. That is only, Milord, the main distinguishing factor, because there, Milord, it's a private transaction. Here, Milord, it's a transaction which was beyond our control. Milord, 69, 68.
Probably you may not raise that issue, but the court can always call upon the SSC to answer, because the preamble of the order passed by the tribunal indicts the SSC for saying that he was not diligent in contesting the matter. So the SSC should come forward with an explanation. He should.
They should.
You ask him, we'll pass a direction that the SSC should file an affidavit.
We will.
As to what was the reason, the frequent change of advocates, and every time adjournment has been made.
My lord.
And this is being called for because 18 times the matter was listed, 14 times the matter was called.
My lord.
This is to protect the interest of
I understand that. I'm very deeply obliged, my lord. Very, very grateful, my lord. I understand what, my lord, we may face it. I understand that.
They will go to any extent.
Lordship.
We have heard Mr. Pranit Baglan, the advocate, appearing for the SSC, assisted by so-and-so, and Mr. Soman Bhattacharjee, and a senior strategic counsel for the respondent department. Before we examine the merits of the matter, we require an explanation from the SSC as to why the SSC did not appear before the learned tribunal, though the though the appeal was listed on 14 such occasions and repeated adjournments were taken, and we also find that from paragraph 2 of the impugned order that the SSC, appellant SSC, had changed the authorized representative on 3 such occasions, and the present learned advocate appearing for the advocate on record for the assessee appears to be the fourth learned counsel representing the assessee. In the memorandum of grounds, nothing has been said as to what led to the non-appearance or frequent change of advocates. Let an affidavit be filed by the assessee clearly explaining the conduct of the assessee and on the next hearing date. 2 weeks.
My lord, very deeply obliged.
Next.
Deeply obliged.
Deeply.
Made prisoners.
Lordship, in item number 8 as well, your lordship, it may be taken up on Wednesday, my lord. Item number 8. Short point, your lordship, but may
So your objections were not disposed of.
My lord, the objections were disposed
That
of.
is one of the technical point, my lord, which has been, my lord, taken note of.
With the decision.
It may be also an hyper technical point.
Yes,
but that's a very
no.
DK and drive shafts has been the law.
There's a decision of my lord, a reported decision in case of Eastern Coalfields, and I believe there are other decisions written on this point. Other decisions as well.
But with regard to, my lord, the reason to believe point, my lord, I believe, my lord, that has actually, my lord, covered up so many issues in favor of the revenue. Because, my lord, has to have a cause or justification. But with regard to, my lord, non-disposal of the objections, my lord, that has been taken out by the assessee, that's something else, my lord.
There's another decision of my There's another report. There's another report. The last paragraph, your lordship, has recorded the objections not having been disposed of. But even
my lord, if your lordship, my lord, take the trouble to, my lord, come into page 12 and 13 of the applications wherein, my lord, the assessing officer, my lord, has gone on to deal with the objections of the assessee, and that has been, my lord, reproduced in those pages. Page 12 and 13 of, my lord, the petition. From paragraph number 3.1, my lord, the assessing officer have, my lord, actually reproduced, my lord, the contentions, my lord, that has been taken out by the assessee during the course of the assessment procedure, and has, my lord, gone on to deal with this.
But in the investigation report, the name of the assessee did not figure.
Didn't appear. Now, my lord, the question is that again, my lord, that may, my lord, take to, my lord, the question whether there was a reason to believe, my lord, to reopen the assessment or not, my lord. In that score, my lord, your lordship is aware of the fact that there has to have a justification or cause to exist, my lord, to reopen this.
The investigation, the report of the investigation department may be a starting point.
Yes, my lord.
It may be a better case for the department if the name of the assessee features.
Yes, yes, that's true.
The script dealt by them, the investment, the loans or advances, etc. Here, there nothing was there because as the tribunal has extracted the reasons. Page 49, Directorate of Income Tax Investigation conducted extensive also. matter of tax evasion by some individuals entities by showing income from LTCG, which is actually bogus, etc. So the second paragraph you say assessee is found to have enjoyed bogus LTCG. There's a missing link. Based on the report, he gathers some material, analyzes his transaction, and say this is prima facie bogus. Explain. Therefore, I want to reopen.
The only thing, my lord, that
I might also consider paragraph 11 of this, on the same page, page 49, my lord. At paragraph 11, the tribunal records that, my lord, I have not claimed any LTCG and I have not shown this amount as a short-term capital gain. Rather, it was a business loss, and 5 lakh was my receipt from the sales. So even factually, my lord, he's not applied his mind to whatever information has come, and he's not conducted any examination. But there's a recent reported decision of my lords, but wherein, my lord, in case of 147, the department received some information. In that case, my lord, in fact, I'm on a better footing. In that case, some layering was found. But nonetheless, the department did not conduct any independent verification, and my lord was pleased to hold following Lakmani Meval Das and Cole Safe that he was bound to apply his mind to the information to assume jurisdiction, my lord. Prashant Desai, my lord. As the entire basis of the decision was that the broker did not respond to the 133.6. Although all documents were filed, Your Lordship. Paragraph 4 onwards, my lord, short decision, but
Oh, this is layer 2, layer 3, layer 4.
yes, in my case, Your Lordship, nothing has been done. At least in that case, the report had some remnants. In my case,
That connection should be established. Normally, they do.
the assessing officer could, my lord, could only establish that there is a JMD Telefilms, my lord, whose name is appearing in that
The
report.
report of the investigation wing says there is lot of individuals entities are showing income from LTCG, which is actually bogus. That is the first paragraph. The report content of the report. Second paragraph, they say he says assessee is found to have enjoyed bogus LTCG. Assessee has enjoyed LTCG. You have for using the expression bogus, there should be some material.
Yes.
Prima facie, so that you confront him that this transaction is bogus for XYZ reasons. Explain.
and in my
That
case,
is why he did not dispose of the objection. He could not.
I could only.
There's no LTCG only. I'm not even claimed under 1030.
That is our facts. On facts, page 50, it has been noted. Sir, please come. This appeal by the Income Tax Department has been filed under section 260 capital A of the Income Tax Act 1961, within bracket the Act, challenging the order passed by the Income Tax Appellate Tribunal SMC Bench Calcutta, within bracket Tribunal, in ITA number 356/KOL/2024 for the assessment year 2011-12. The revenue has suggested the following substantial questions of law for consideration. Page number 7, question 1, 8, question 2. And question 5. We have heard from. The department is aggrieved by the impugned order passed by the tribunal, by which the learned tribunal allowed the assessee's appeal and set aside the order passed by the Commission of Income Tax Appeals, within bracket CITA, dated 29th January 2024. By the said order, the CITA allowed the assessee's appeal. No, sorry. By the CIT dismissed the assessee's appeal.
Yes, CIT appeal, revenue
Dismissed the assessee's appeal and affirmed the addition made by the assessing officer in the assessment order dated 20th December 2017 under section 143 within bracket 3 of the Act, 3 read with section 147 of the Act. The issue which fell for consideration before the tribunal was whether the reopening of the assessment was under section 147 was legally sustainable. After elaborately hearing the learned advocates for the parties and carefully perusing the materials placed on record, we find that the reopening was done by issuing notice under section 148 of the Act dated 28/3/2016. The reasons mentioned for reopening are quoted here under page 46, sir. It should be in italics. You please indent it. As could be seen from the above, the first paragraph of the reasons is a general statement wherein the Directorate of Income Tax Investigation, upon conducting extensive investigation in the matter of tax evasion, found that some individuals/entities were showing income from LTCG, which is actually bogus, perpetrated through accommodation entry operators. Further, the report states that it is found that promoters of penny stock, the share brokers and entry operators are involved in this business of bogus LTCG by rigging the prices. Thus, it is evident that in the report of the Directorate of Income Tax investigation, the name of the respondent assessee does not feature. Therefore, we are well justified in holding that the report is a general statement. In the second paragraph of the reasons for reopening, it is mentioned that the assessee is found to have enjoyed bogus LTCG by transacting in penny stock.
And also short-term capital.
The
word
bogus, inverted comma, which is found in paragraph 2 of the reasons for reopening, should have been used after independently considering the assessee's return of income and other details. This is required to be done because before issuing notice under section 148 of the Act, the assessing officer must have either reasons to believe that by reason of omission or failure on the part of the assessee to make a return under section 139 for any assessment year to the income tax officer, or to disclose fully and truly or all material facts necessary for his assessment for that year, income chargeable to tax as escaped assessment for that year, or alternatively, notwithstanding that there has been no omission or failure as mentioned above on the part of the assessee, the income tax officer has, in consequence of information in his possession, reason to believe that income chargeable to tax has escaped assessment for any assessment year. This aspect of the matter is conspicuously absent in the reasons which were recorded for reopening the assessment. The second error committed by the assessing officer is not disposing of the objections raised by the assessee for the reopening of the assessment, and by submitting a reply to the show cause notice dated 28/3/2016. This being a mandate under law as held by the Honorable Supreme Court, in the case of GK and Drive Shafts versus ITO and others, 2003, 259 ITR, 19 within bracket SC, goes to the root of the matter, rendering the reopening of the assessment as bad in law. At this juncture, it will be beneficial to note the decision of the Honorable Supreme Court in the case of Income Tax Officer versus Lakmani Mewal Das. It is here, sir, in this judgment, wherein the Honorable Supreme Court held that reasons for the formation of the belief must have a rational connection with or relevant bearing on the formation of belief. Full stop. Rational connection postulates that there must be a direct nexus or live link between the material coming to the notice of the income tax officer and the formation of his belief that there has been escapement of income of the assessee from the assessment in the particular year because of his failure to disclose fully and truly all material facts. It was further pointed out that it has to be borne in mind that it is not any and every material, howsoever vague and indefinite or distant, remote and far-fetched, which would warrant the formation of belief relating to escapement of income of the assessee from assessment. The learned advocate appearing for the respondent assessee also place reliance on the decisions of this court. Give the three citations, these three. It is not the respondent. The above decisions also would support the case of the assessee. That apart, the tribunal has considered the factual position in paragraph 10 of the impugned order. After going through the computation of income as well as the objections raised by the assessee against the initiation of proceedings under section 147 of the Act, and observed that the assessee has not earned any long-term capital gain during the year. Full stop. Further, there is no exemption claimed under section 10 within bracket 38 of the Act at rupees 5, 47, 749 in the income tax return. Furthermore, the learned tribunal perused the profit and loss account, net income from sale of investment, and found the same only to be rupees 12,500. Further, with regard to short-term capital loss, which was rupees 35, 31,930, it was brought to the notice of the tribunal that during the year, the assessee purchased 30,000 shares of JMD Telefilm for consideration of rupees 35, 36,867, and the same was sold at rupees 5, 46, 663, incurring a loss of rupees 29, 90, 203. Thus, on going through the profit and loss account, the tribunal found that the assessee has not shown any long-term / short-term capital gain / loss, and purchases and sales of such shares are treated as stock in trade. Hence, the loss in such scripts were claimed as business loss and not capital loss. Thus, we find that apart from the jurisdictional error, which was pointed out by the learned tribunal, the factual position has also been discussed by the learned tribunal. Thus, we find no grounds to interfere with the impugned order. Accordingly, the appeal feels dismissed. The substantial questions of law are answered against the tribunal.
I bow down before Lord.
Deeply.
Unappealed for that. My lord, on the last occasion, it was submitted on behalf of the assessee that reasons recorded for reopening was not supplied to the assessee. So my lord had directed me to ascertain whether reasons were supplied to or not. Reasons were supplied. Yes, my lord. My lord, I'm showing the relevant pages. My lord, kindly come to page 6. The show cause notice. In this notice, all the reasons have been stated. And thereafter, my lord, kindly come to page 10.
Okay.
Last page.
Yes.
This is the response of the assessee. I'm reading on. With reference to the above mentioned notice dated 6/12/2019 for the assessment at 12/13, we would like to inform you that as per your data, you have received the information from investigation wing of department that SFIO has carried out investigation in NHCL, which has discussed the issue of client code modification in the case of few brokers and our company, Mesa Seaside Projects Private Limited, whose name is included in the list of modified clients in the details provided by the NHCL. In the connection of the above context, we would like to submit that we are not aware of any client code modification and no intimation has been received from broker in this. And the assessee has offered tax.
27,000 and odd.
So, my lord, the assessee was aware of the reason, but assessee did not participate in the assessment procedure.
But where does the tribunal hold that reasons were not furnished? Is it correct?
No,
my
that
lord.
is not there.
No,
But it was submission.
Submission.
my lord, lordship can see tribunal.
But the client has accepted it. He says, I can't modify the client code. It is not within my powers. But however, to buy peace, he is offered 27,000 as additional income. What was your grounds of appeal before the CIT appeals?
Before.
Or
My lord,
did
the
the
CIT has appealed. CIT
Grounds of
appeal has
appeal, CIT appeal.
discussed the grounds, my lord, at page 33, para 6.2.1. Decision. The second is paragraph 6.2.2. Basically, my lord, the assessee has challenged the reopening of the assessment.
My
So that ground is not available. You have received the reasons.
Yes, my lord, but reopen is barred by limitation that I said last occasion. And moreover, my lord, reason to suspect cannot be a reason to believe. I can rely a order of writ court of Bombay High Court. There the similar point was taken on the client code modification.
So the first ground is gone. The second
Limitation.
ground is that facts and circumstances, the notice issued under 148 is illegal.
Yes, yes. And my lord, if your lordship see para 41, there page 41 para 4, per contra learned dear placed the reliance on the orders of the authorities below and submitted that SSC has failed to produce any details and explanation in respect of the benefit arrived by it from the client code. So client has not, SSC has not taken any benefit. And reason to suspect cannot be reason to believe, my lord. This is the latest judgment of Reed Court, Bombay.
but the onus was on the assessee to prove that he was not the beneficiary of the alleged client code modification. Because your reasons were recorded, furnished, you have raised some objection, accepted, etc. Then whether credible information was available, it is not a vague statement. National Stock Exchange Limited has provided details. So that is also gone. The third is whether there was justification for reopening. For that, the onus lied on the assessee that, first of all, his plea is, I can't do the code modification. It is beyond my power. That we don't know, that we could have explained the procedure. Secondly, there is something to indicate from the National Stock Exchange that the assessee is a beneficiary. You should say that, no, I did not get a single pie out of that. I was not in brain. That they missed out.
Lord, that has been stated by the learned dear in.
So the tribunal has gone mainly on the point of the limitation point, that is the 147 proceedings, whether it is valid or
And
not. That has been dealt with by the ITAT in detail. That part only.
It has been stated by the learned dear, my lord. Page 41, para 4. That client, the assessee is not.
No, this para 5, page 42, this finding is wrong. It lacks reasons to believe is wrong because National Stock Exchange information was to the point. No, reasons to believe is adequate. Tribunal finding saying that it is general observation is wrong. Normally, they don't record reasons so well. And this is also by SFA, Serious Fraud Investigation Office.
And the assessee did not participate.
That is why probably they were advised to accept and offer additional income. That's why they say to give peace of mind. This appeal by the revenue filed under section 260 capital A of the Income Tax Act 1961, within bracket the act is directed against the order dated April 10, 2024, passed by the Income Tax Appellate Tribunal, SMC Bench, Kolkata, within bracket Tribunal, in ITA 172/KOL/2024 for the assessment year 2012-30. The revenue has raised the following substantial questions of law for consideration. Page 6, sir, 1 to 5. We have heard so and so. The learned tribunal, by the impugned order, has allowed the assessee's appeal and set aside the order passed by the appellate authority dated 21/2024, by which the appellate authority affirmed the addition made by the assessing officer by order dated 13/12/2019 under section 143, 147, read with section 144 of the Act. The first contention which was raised by the assessee, by way of a preliminary objection in this appeal, when it was heard earlier, was that the reasons for reopening were not furnished to the assessee. This court directed the learned senior standing counsel for the department to get necessary instructions in this aspect. Accordingly, the instructions received from the department have been placed before this court, from which it is seen that the assessee has received the reasons for reopening and has also submitted their reply and in dated 13/12/2019, and also have stated that they are offering an additional income for for purchasing peace. Therefore, the contention raised by the assessee that reasons for reopening were not furnished to the assessee is shown to be factually incorrect, and therefore that said objection raised by the assessee before us stands rejected. The second contention is that second contention which was raised by the assessee before the learned tribunal and found favor of the learned tribunal is the ground that the information received from the investigation wing are certain general observation, and that the assessing officer did not investigate on his own and record satisfaction as regards the escapement of income in the hands of the assessee for the relevant assessment year. To examine this aspect, we have perused the reasons to believe, inverted comma, dated reasons to believe, which was recorded by the assessing officer by proceedings dated 28/3/2019. In the said reason, it has been stated that the assessee filed its return of income on 27/11/2012 for the assessment year 2012-13, declaring total income of rupees 7,820. The return was processed under section 143 within bracket 1 on 23/3/2013, accepting the return income. Full stop. Scrutiny assessment under section 143 within bracket 3/147 was completed on 2/5/2018. Further, it states that in the case of the assessee, on the basis of inquiry and information in the possession of the assessing officer, it has come to light that SFIO has carried out investigation in NSEL, which has discussed the issue of client code modification in the case of few brokers. Full stop. Further, it states that the findings of the investigation of member-brokers and traders were perused by the assessing officer, and the details of client code modification were called for from the NSEL. As per the data, there are totally 219 brokers who have made 54565 client code modification, and the volume of sale and purchase transaction is rupees 6311 crores. Full stop. Further, the assessing officer specifically records that the brokers and the client in whose favor client code modification are made are spread over India, and the assessee is also one of the clients whose name is included in the list of modified clients in the details provided by NSEL. The other relevant details with regard to the privity of contract between the clients and the respective brokers was also brought on record. Thus, the assessing officers would state that a comprehensive investigation/inquiry and verification of data possessed by the department, and after due application of mind, the assessing officer has reason to believe that the assessee is the beneficiary to the tune of rupees 27,93,150 by way of client code modification during the financial year 2011-12 relevant to the assessment year 2012-13. Hence, on the basis of the information collated and the analysis done by the assessing officer, he was of the view that the assessee company has not disclosed the true and full income. Thus, the assessing officer proceeded to issue the notice under section 148 of the Act, for which approval was obtained from the principal CIT-2 Calcutta. Therefore, the tribunal fell in error in holding that the assessing officer did not record his satisfaction, nor conducted any inquiry or investigation before issuing notice under Section 148 of the Act. Therefore, this contention, which was raised by the tribunal and accepted by the tribunal, is incorrect, and therefore the revenue should succeed on the said point. Furthermore, the onus was on the assessee to establish that they were not a beneficiary on account of the modification of the client code. Despite opportunity being granted to the assessee did not produce any evidence either during the course of assessment proceedings nor at the first appellate stage to show that he is not the beneficiary of the said amount due to client code modification. Thus, we are of the view that the tribunal committed an error in allowing the assessee's appeal. For the above reasons, the appeal filed with the revenue is allowed, and the order passed by the learned tribunal is set aside, and the assessment order dated 13/12/2019 passed under Section 143 within bracket 3/147 read with Section 142 of the Act as affirmed by the appellate authority by order dated 21/20/24 under Section 250 of the Act stands restored. Consequently, the substantial questions of law are answered in favor of the appellant tribunal. Next,
my lord, this is also pertaining to reopening of the case.
Your Lordship, in item number 10, I've just received the instructions, my lord, just in the morning. And my lord, I'm sure my learned friend would have served, but I only have a copy of the condonation of delay, which I'm told has been condoned. Random,
my lord, I can always provide.
Must have been served, but my instructions, it hasn't been, but I'm sure he must have.
That is not an issue. My lord,
It will be taken up after 2 weeks, my lord.
Already. So and so. Mr. Gunjanwala accepts notice for the respondent assessee and seeks for time to get instruction. At least after 2 weeks.
I'm grateful, Your Lordship.
Responded.
May it please, Your Lordship.
11 and 12 are same as
Same assess and same issue as well.
And assessment here.
Only difference is my lord, the assessment here.
1566.
It's a very interesting matter, my lord. 263 jurisdiction has been exercised. And my lord, that has been, my lord, assailed before the tribunal, and tribunal had held that, my lord, the 263 jurisdiction has not been properly exercised. If your lordship kindly turn to page 19 of the applications, wherein, my lord, relevant portions of the 263 order, my lord, first of all, my lord, I'd like to indicate to your lordship.
Yes.
My lord, the assessment order, my lord, which was the subject matter of the 263 jurisdiction, was actually a reassessment. Because initially, my lord, at the original return, my lord, the assessee have not disclosed the entire fact. Thereafter, it was found that the income has escaped assessment. My lord, the reassessment has been initiated, and my lord, the assessing and the assessee has participated. Now, my lord would find it from page 19, wherein, my lord, in first paragraph, it has been indicated that what was, my lord, my lord, the subsequent fact that was found, and, my lord, then the 147 jurisdiction has been exercised. Now, my lord, while exercising this, the learned commissioner has found the relevant portion starts from, my lord, paragraph 2.1 of that 263 order. The huge amount of, my lord, the cash was, my lord, found credited in the account of the assessee for the relevant assessment year, which was not there and which has not been considered by the assessing officer while passing 147 order. Page 22 is, my lord, the sum and substance of the factual aspect of, my lord, the 260 order, which has actually indicated, my lord, and finally, my lord, the commissioner have directed, my lord, the de novo assessment to be done. Lordship had got it, my lord, page
Para 3.
para 3.
Please read.
Yes. A perusal of the documents on record shows that the total deposit in various banks amounting to rupees 30 crore 3,78,690. It is observed that the assessing officer estimated 8% of the cumulative amount of the disclosed and undisclosed deposit as income of the assessee for the assessment year 2015-16 and added the profit amount of rupees 2 crore 39,49,389 besides the consideration amount for one immovable property, treating as unexplained investment coupled with returned income as assessed income vide ordered under section 147, read with section 144 and 144B of the Income Tax Act 1961 on 28 September 2021. The assessing officer has made an estimated addition of rupees such and such on the business turnover, which is on the lower side of and contrary to the law. The assessing officer has not given any reason whatsoever on computing the income of rupees such and such at the rate of 8% on entire deposit amount instead of the total credit of rupees such and such in various bank accounts maintained in the name of the assessee. In view of the above facts and circumstances, the assessment order passed by the assessing officer was found to be erroneous and prejudicial to the interest of the revenue. Accordingly, the assessment order is proposed to be reviewed in exercise of the power conferred under section 263 of the Income Tax Act 1962. So, this was the sum and substances. And if your lordship kindly turn to the ultimate directions that has been passed by the assessing officer, the commissioner, is at page 59 of your lordship's brief. Paragraph number 7.5, your lordship.
No, before that, what was their reply? Page 22.
Page 22.
Assessee, my lord, has gone on to, my lord, deny the entire credit on their account. Neither they have stated that they have got no knowledge about those accounts. Neither the PAN was belonging to them. They have, my lord, blatantly, my lord, denied, my lord, the credits, my lord, that has been found credited in the accounts of the assessee.
My lord, may I interrupt, my lord? My lord, the stand was that these IDs of the assessee have been forged. It is not that I never stated that it is not my PAN. My lord, it was a standing that the accounts have been forged and we have no knowledge about these deposits. And FIRs were filed before the police authorities and even an affidavit was submitted. That was the stand. And my lord, during the pendency of the appeal before against the 147 order, they have invoked 263. And tribunal has gone on that. My lord, that part is covered by my lord's own decision.
The reply of the assessee, my lord, has been reproduced in page 29 of, my lord, the 263 order.
But why you would not? Why did you not challenge that 8%?
My lord, that we have challenged, my lord. I was about to submit.
Ah,
My lord, may kindly have a look. My lord, may only take the IT-80 order for a moment, my lord.
no, you have challenged it by way of appeal to the CID.
Yes, my lord, we've challenged that by way of an appeal. Today, that order is also in my favor. Today, that order has come in my favor. And my lord, that is what I was submitting, my lord.
Oh, that order came in your favor.
Yes, by the CIT.
Thereafter, 263.
My lord, 263 during the pendency, which is not permitted, my lord. IT-80 has gone on that line. And my lord, that is again covered by my lord's own decision.
The assessee's case itself, its fraud has been played. Using his Aadhaar and PAN, substituting the photograph,
Yes.
7 bank accounts have been opened, in which transaction has been made. Whereas he is a small trader in textiles in a hut somewhere in a village, small village, and he has lodged a police complaint. We don't know what is the outcome of the police complaint. Yet the assessing officer, in spite of having said all these things, he reopened the assessment, made an addition on a presumptive basis by putting it at 8%. That he challenged, appeal was pending. In the meantime, 263.
So that is, my lord, with regard to, my lord, the fact that, my lord, this account was found to be, my lord, open in his name. Now, my lord, when
he has set out that.
But, my lord, whether kindly ascertain, my lord, whether, my lord, the pendency of that appeal, my lord, assailing that order was, my lord, placed before, my lord, the commissioner when 263 order proceeding was going on.
Obviously, the department will be aware.
My lord, kindly see, my lord, his reply to this.
This appeal is filed. My lord, may have a look, my lord. This appeal also is filed on 20th March 2025, the present appeal. My lord, the order was passed on September 2024.
But, my lord, kindly see.
So if they are saying that, my lord,
No,
this
it's
should
not.
also be taken.
I'm not on that one. Kindly turn to page 24, wherein, my lord, in 263 order, my lord, the commissioner had reproduced, my lord, the submissions that has been made before the commissioner during the course of the reassessment, revisional proceeding.
But did you point out in your reply to the 263 that your appeal against the...
No. That's what I'm trying to indicate to your lordship. That's what I'm trying to indicate to your lordship. That will appear from page 24 of your lordship's brief.
My lord, that was pointed out, my lord. That is there before the IT-80. And my lord, IT-80 has gone on that.
Yes.
IT-80
That was
has
first
gone
time
on that
placed,
only, my lord.
first time placed before the tribunal.
The issue of page number 44, 42, 41, 42.
There was a second notice that was also served upon the assessee during, my lord, the 263 proceeding. That notice, my lord, would appear at page 41 of your lordship's brief, wherein, my lord, the concerned commissioner was, my lord, very specific in, my lord, inquiring from the assessee about, my lord, the outcome of the criminal investigation that has been initiated on the basis of the complaint lodged by the assessee. Nothing has been replied to the commissioner from the assessee, my lord. Lordship would find it at paragraph number 4.3 appearing at page 42. The last paragraph. They have only shot for time, my lord. Didn't apprise anything.
But where is that order passed by the CIT appeals in a 250 appeal under section 250? Have they challenged this before the tribunal?
My lord, I have instructions that till now they have not done anything.
Till not.
My lord, only one passage, if I may show from the ITAT order. Let me kindly have a look only at page 92.15.
Yet not a challenge to the CIT appeal.
Oh, this was after the tribunal, sir.
Yes.
The tribunal allowed your appeal against 263 on June 12.
Yes, my lord. This was after the order.
Commissioner's order is on September
The
9.
tribunal had just gone on to hold that that appeal was pending at the time of pronouncement of the before the trial.
What the tribunal says is that if an appeal is pending, as per clause C of section 263, if an appeal is pending, you cannot exercise the 263 jurisdiction. My lord, on this, my lord will have my lord had the occasion to consider this. My lord, may kindly have a look at my lord's own judgment. That's true.
We have heard so and so, so and so. For continuation of arguments, you list it. This is 11 and 12.
No.
11,
Yes, 11 and 12.
Both the matter.
Both. 11 and 12.
এটা একটু রাখবো, দেখে তোমার বিয়ে check করবো।
Second of the supplements.
আপনি দেখেন।
So CIT appeal.
Before your lordship rise, my lord, if your lordship, before your lordship rise, my lord, if your lordship permit me to mention, due to peculiar circumstances, my lord, there is an extreme urgent matter, my lord. We want to move before the Honorable Justice Honorable Justice Saugata Bhattacharya taking the determination of Justice goes police in action. Police has given a notice. Now, my lord, asking us to appear before them today. Now, my lord, ultimately,
Senior is appearing.
now, my lord,
How I can ask the judge
no,
to
my lord,
take it up?
his lordship is not granting the leave. If your lordship subject to correction, what we call in from whatever your lordship will decide. If we not move the matter, whatever may be the order, but if your lordship assign the matter in any other court, my lord.
No. On the administrative side, how I can say that the judge should take it up now?
No, I'm not on the subject. That, my lord, up to your lordship. My lord, only thing is.
No. If you go and mention at 2 p.m., saying that you mentioned before Chief Justice and Chief has said that you have to mention before the court having determination, at least you get leave to file today.
But that we, in the morning, we have done that. His lordship was kind enough to refuse to grant the leave. My junior mentioned twice, my lord.
This is putting me in embarrassment.
Urgency is that, my lord, if we don't move or take the leave, my lord.
Then you tell the police that you are moving a writ petition, ask them to defer. I can't pull it out.
Subject to have, we will again mention before Justice Bhattacharya at 2 p.m. If Justice Bhattacharya, my lord, don't release the matter, kindly permit us to, my lord, kindly permit to move before. I know, my lord, I know, my lord.
How to do it? How to do it, sir?
Difficulty is that, my lord, whatever order may be.
Or you try once more. You say that you went and mentioned. Then I have said that you once again go and mention that. Let us see.
Lordship, kindly allow me to mention item number 17 of your lordship list. Last occasion, it was adjourned only the particular order which is effective for the case was not available with the record. So may I hand over it and it may be taken into the record as in the case of virtual hearing also I can place it.
All right. Taken on record. Yes. What is this order?
Actually, that appeal is not maintainable because it is for the assessment year 2014-15.
Now, what is this order?
This is the order that that appeal is not maintainable because of that already the
You give copies to them.
I already given the copy to them, my lord.
Oh,
So
for
that
liquidation.
Yes. For the NCLT already approved my resolution plan. That is why
the orders passed by this court in IT 147 of 2024 has been submitted, which is taken on record.
Grateful, my lord.
Yeah, check.
mention one matter for inclusion. Fresh matters. Much obliged.
My lord, may I be permitted to mention one matter for upgradation, my lord? That matter is in the monthly list of this month, 9th.
What is the urgency?
My lord, urgency, I am the removed employee since 2022. Now I am out of my livelihood, my lord. I am passing my days with acute financial crisis, lordship.
And what happened to your writ petition?
Yes.
What happened to your writ petition?
What? Read petition. My lord, read petition regarding challenging my removal order, my lord, appellate authority's order. In the read petition, I am directed to reinstate with immediate effect.
Oh, the
but
appeal is by the...
appeal is pending before your lord.
No, which department is the...
My lord, CRPF, RPF.
RPF.
Railway Protection
Force. Who will appear for RPF?
My lord, Kollan Chakraborty.
But if you mention...
Yes, I have a notice to the other side, my lord. I have annexed the notice here.
You take the file and see whether we can include.
Item number 76 of monthly list dated 9th June.
We can't tell on what date, but we'll try to...
May I have a lordship chief to mention matter for inclusion, matter, hearing matter.
My lord, you permitted to mention matter. I have one has been granted by one, and the department has preferred appeal against that. And some benefits have not been granted to me. That's why I have also preferred appeal. And both the appeal has been admitted and it was directed by another coordinate bench that it will appear in the list of February, but till then. So my lord, the urgency. But
we'll see what can be done.
May I have a lordship's kindly
notice I am mentioning.
May I have a lordship's kindly to mention item number 88 of your lordship's monthly list. That the urgency is that in writ petition, the order has been passed in favor of me, thereby directing the respondent authority to pay the amount that was pending to them. But now thereafter they did not pay it. I filed the contempt that is pending. While during the pendency of the contempt application, they have preferred this appeal.
Stay has been granted?
No, stay has not been granted. But since the appeal is pending, the
contempt is being adjourned.
Yes, if some accommodation could.
This is group 6. No?
18 monthly, so daily monthly list.
Group 6 matter.
Group 6 matter.
One day, actually, we have not fixed a particular date for group 6. Shall we fix next week onwards? All the days means we both group 4 will also come, group 6 will come. Probably we have one day. We think over it. We'll decide.
May I hand over the seat?
Yes, Mr.
Lord, may I request the Lordship that the matter which your Lordship has heard substantially with Honorable Justice
Megaflex.
Kindly.
Before September, we'll try to do.
That is what.
Interesting matter. Let us see.
That has been heard.
Back to back, there's so much of administrative work, sir. After that, then today, 4 o'clock.
Last week, your Lordship was not well.
5. So I'll be hanging around here till 8 o'clock. What to do?
Kindly, my lord, because that has been heard already.
The other bench has to be constituted.
That is why.
And his lordship is also quite, it's a very heavy bench, civil revision. Justice Bhattacharya's bench also is a single bench, is a very heavy bench. For him to spare half a day, it will get blocked. We have already on it.
This will not require more than, I will not, my lord, make any submission on rejoinder. That time, my lord.
Mr. Siddiqui wanted to cite some judgments.
Not Mr. Siddiqui. Mr. U.S. Bhattacharya was arguing.
Yes.
He only had to distinguish the judgment cited by. That is all that is left.
We'll do it at the earliest.
I will, my lord, not argue anything further.
Okay. Only this is live streamed. We will play back and then.
Yes, my lord, I will not.
You will be stopped from doing that.
No, I give my.
No issues. Just on a lighter way. We'll do something. Okay. Please call.
Appellate side daily list, serial number 1.
Lord, I appear in this matter on behalf of the appellant. South Bengal State Transport Corporation employees are before your lordship, my lord, for redressal of the grievance regarding the grant of the pension in their favor.
I appear for the corporation, my lord. Respondent number 5, 6, and 7 may file my opposition, my lord, to their application.
Now, why is it listed under the caption to be mentioned? Because
It was mentioned as an urgency, Lordship wanted to person, sir, my lord.
Almost 80 years.
Oh.
Persons are nearing 80 years of age, my lord, who are not
Yes,
getting
yes,
their
yes.
pension.
That's what was mentioned. And how
Lordship-
much time you are likely to take, both of you put together?
Well, I am to place the judgment. Judgment is a very voluminous judgment, my lord, and I am to place my case, my lord. I shall take maximum 1 hour. If your lordship does not interrupt in the meantime and say that yes, I am allowing your appeal, I will be only taking the time to be fixed by lordship.
And the learned judge said you are not entitled for pension.
Not entitled to. I am a fence sitter.
It is a case of not exercise of option. Time limit for option was given in the my lord's pension regulation. They, my lord, did not opt within that time. They retired, got the retirement benefits, my lord, under CPF scheme. After some years, my lord, they
No, we objected to the said option provision that you are just framing certain rule, my lord. We are state government employees. This is not at par with the state government employees. It is much lower than the standard of the pension being given to other units of the transport department.
If the pension rules applicable for the state government employees is made applicable to the transport,
we are agreed. We are agreed. We have no objection to that.
Then, if the rule contemplates exercise of option within a time frame, and if you don't do it, then
we have objected to the said rule. We have made an objection to the finance. Finance said, wait, it is before the Supreme Court, the matter is going on. We shall be giving answer to that, but we shall take your answer after the Supreme Court matter is over. That's why, my lord, we did not.
One thing.
Can you fix a date, my lord?
After 12th July. Sir, give a date after 12th July. Probably on 16th July.
The affidavit will be taken on record.
Yes.
First 16th July, my lord, specially fixed.
Yes, yes.
Kindly keep it fixed in July, my lord. They are waiting, my lord.
Immediately after fresh case.
Kindly look at the face of our litigants, my lord, who are just standing behind. My lord, my reply to the said affidavit we
Affidavit in opposition filed by respondents 5 to 7 taken on record. Reply given by the appellant to the said affidavit is also taken on record. Let the appeal be fixed for hearing on immediately after fresh case.
16th July.
Next.
Real number 225.
Lordship, in 225, Your Lordship, I'm being led by the Advocate General, Your Lordship. He's on legs in courtroom number 11. He's arguing the matter. Your Lordship, may kindly fix it for some other date, Your Lordship.
What was the last order? What
minutes? On the last order.
That is dated 10th of April, correct?
10th of April. Milords, we're considering three primary issues, Milords. If I may just indicate.
No, let us see the order.
Milords.
10th of April.
Your Lordship, the last order would be 13th
Para
of...
10, 11 and 14 are the relevant paragraphs, Milords. From 10th April order, Milords. 10th April 2025. May I just read out from the paragraphs,
We
Milords?
require a response from the appropriate authorities and the government. Number 1. As to what procedure is to be adopted for utilization recovered amount lying with the state nodal account. Concerned authority of central government shall give specific written instruction. The broader wise scheme should not be diverted to be implemented prospectively. Yes. So who will appear represents the central government? Major, the large part of the direction is.
In terms of your lordship's order, you are required to file one affidavit. Affidavit.
Affidavit or written instruction, whatever.
That affidavit is ready, lordship. But I was only beseeching your lordship that since I'm being led by learned additional solicitor.
No, we'll see. He has been mentioning 100 times. List this matter, list this matter. So you please give the affidavit, serve a copy on them.
We've
Then
received
let him go through it.
received an advance
We'll have
copy.
it probably on Wednesday, Thursday.
The hard copies of the affidavits are with the additional solicitor, and he is engaged in court number 11, lordship. Those especially fix those OBC matters which are going.
No problem. So we can fix this matter on Monday, same position. Probably by Wednesday, you give him a copy.
Milords, we've received an advance copy, Milords. Milords can have it tomorrow, day after tomorrow, whenever it's.
If your lordship so deems fit and subject to lordship's convenience, if your lordship then kindly takes up on this Wednesday, lordship.
So you have received the affidavit.
Advance
What
copy.
about you?
I have.
We haven't.
To the state, lordship.
We haven't received a copy.
But of course.
Your lordship will coordinate and that's all.
But state, then you come to para 13 of that order.
Your lordship,
14
this
minutes.
the learned advocate.
14 minutes.
14, your lordship. This the learned advocate general who want to argue, your lordship, on this direction.
What is your response? Would you like to put something in writing?
Your lordship, in that case, your lordship, we'll bring out a short supplementary affidavit, 2 pages supplementary affidavit written.
This affidavit business is going to take time.
Your lordship.
So the question is very clear. The state government shall also answer to the direction given in para 14 of the order dated 7th October, wherein court directed state government to answer as to why direction should not be issued to the state government for unemployment allowance, since admittedly employment is not being provided to the unemployed for the past 2
Your
years.
lordship.
Yes, no. If it is yes, what are you going to do? If it is going to be no, mostly it will be no. Why it is no? That's it. You ask your officer to address a letter to the state advocate. This is our stand.
Your lordship, we'll do that.
That will be enough.
Your lordship, we'll have the written instructions on the next day.
Yes.
We'll have that, lordship.
That you circulate, give him advance copy.
We'll do that, lordship. Your lordship, in that case, kindly have it on probably Monday. Your lordship,
This
we'll take
direction
the
is lying
written
from
instructions,
October.
serve them in advance.
The direction is lying from October 2 times. Milords have reiterated.
All right. What we
They have
do
not
is,
responded.
We'll serve them in advance.
Unemployment allowance, probably we'll hear the AG and if appropriate, we'll adjourn.
Milords.
So far as central government is concerned, let the affidavit come on record.
Milords.
We'll have it on Wednesday.
Milords. I'm deeply grateful, Milords.
I am for the petitioner in item number 5. The issue involved in 4. I'm sorry, madam. The issue involved with the same, madam. If the union, madam, provides a copy to us, maybe we can also respond.
Yes, so you provide a soft copy to your friend also.
Yes, that will do. Soft copy.
He is appearing in item 4.
Lordship.
These matters were mentioned, citing urgency in the prayer made by the petitioners, and they were listed under the caption to be mentioned. We have heard the learned advocates appearing for the parties. Paragraph 10 of the order dated 10th April 2025 contains certain directions to the appropriate authority of the central government. Similarly, in paragraph 11 and 12, also certain directions/observations have been made for which the appropriate authority of the central government has to respond. The learned standing counsel appearing for the central government submitted that an affidavit has been sworn in and it will be filed on the next hearing date, advance copy of which has already been provided to the learned advocates for the writ petitioners. Let the matter appear on next one. There is a direction issued to the state government in paragraph 14. The learned counsel appearing for the state submitted that the learned advocate general is appearing in the matter and they are awaiting instructions. Let the matter appear on this Wednesday, on which date the court will consider the affidavit which will be filed by the appropriate authority of the central government. Immediately after fresh cases.
Milords, retaining the same position, Milords.
Immediately after fresh cases.
Milords,
It
The
will come.
difficulty, Milods, the difficulties, Milods,
If-
I may only indicate,
then if you want, we can release the matter.
Milods, may kindly consider,
You
Milods.
take your turn, sir. Nothing.
Milods, this matter is running in the same caption. Today, effectively, Milods, it's not.
But then fresh cases have to be given some priority, no?
Milods, I understand, Milods, but the difficulty is, Milods, their right, Article 21 right is being suspended for last 3 years, Milods.
We will have only 5 or 6 cases. On that day, probably it's getting delayed. We will pass over the other matters and take up.
So I'm grateful.
Your Lordship.
Next.
Serial number 6.
But Mr. Kosik, they is just coming. He's in code 17, I am told.
All right. Short pass over.
Short pass over.
But today may be difficult, Mr. Sharaf, because 4 I have got a meeting.
4. Not today, then.
Not today. Huh?
Tomorrow I will come.
Serial number 7.
7, my lord, the appellant, my lord.
I appear for the respondent number 1 writ petitioner.
So prior to my lord starting, my lord, during the pendency of appeal, my lord, the bank is become amalgamated with other bank, my lord.
So you have to amend the cost item.
My lord, praying for.
That is only ministerial act. You have to file an application, is it?
Yes, my lord. Application is also there, my lord.
You can't correct it.
No, my lord. I've filed an application.
No.
You have filed or not filed?
No.
Not yet filed, my lord.
Recently, my lord, it's amalgamated in the last
Simply
month.
the cost title is to be corrected, my lord. Let it be done and let this matter be taken up, subject to my lord kind consideration on tomorrow. Let it be corrected today only. The
Today,
cost
how
item.
we will file the application? It's already 3:15.
Application is good. You're supposed to application.
It is submitted by the learned advocate for the appellant bank. That very recently the appellant bank has been merged with
2 other rural banks, my lord.
2 other rural banks, and they are taking out an application for amendment of cost title. Let the matter, let this application be listed along with this appeal next Monday.
Ma'am.
Next one. Serial number 8.
My lord, deep lock. Next Monday, my lord. But tomorrow, actually, there is a matter fixed in code number 5, actually, at 2 p.m.
Day after.
So
Thursday.
Thursday, my lord. Kindly make it.
Item number 6, Thursday.
Same position, my lord.
Same position.
Grateful.
Thursday. Kaushik is there.
Oh, he has come, my lord. If your lordship wants to take up, except Thursday.
Next.
Serial number 8. Serial number 9.
Well, I'm playing with short pass over, my lord. My learned friend is here, my lord. Just now he has gone out. Only within 5 minutes.
Who's appearing in 8? Union of India. Harsh Transport.
My lord, he has come, my lord.
Let him come.
Item number 9, this 9.
Oh, 8.
Oh, wait, not my lord. I mean 9, my lord. Sorry. I'm to 9 now.
Serial number 8.
Only loading and loading.
Who they can modify, but she says that coordinate bench decision. Oh, what is it? Find it. Railway, the authority present appellant challenging the said order dated 6/7/2022. Sora Ghosh order.
What is this one?
No.
No.
6 July. This please file. This intra-court appeal has been filed against the order dated WPA 21852 of 2022, dated 23/9/2022. By the impugned order, the learned writ court has disposed of the writ petition by relaxing/modifying the notices dated 24th/27th June 2013 and 1st July 2013 to the extent that the writ petitioner shall be permitted to load and unload perishable goods to the extent of 5 tons from the railway station at Howrah during the time allotted by the railway authorities. The writ petition was disposed of following the directions issued by a coordinate single bench in WPA 12872 of 2013, dated 172 of 2022, dated 6th July 2022. As could be seen from the memorandum of appeal, against the said order, the Union of India filed intra-court appeal in MAT 12 of 2023, and the said appeal was entertained by the division bench, and an order of stay has been granted on 6/7/2023. In the light of the above, this appeal is also entertained, and there will be an order of interim stay of the impugned direction. Let this appeal be listed along with MAT 12 of 2023. In page number 220. 232. MAT, what is the MAT number I said?
MAT is
12, huh?
12 of 23.
Ah.
That appeal order is there.
Accordingly, this appeal is admitted and directed to be listed along with MAT 12 of 2023. In the said appeal, all the appellant is directed to file the informal paper book before the next hearing of the appeal.
Serial number 9.
I am for the appellants, my lord. Here is the affidavit establishment.
Yes, sir.
Here is the affidavit of establishment. My lord, the ambit of my memorandum is actually very small. But if that is appreciated by your lordships,
then only may ramify into other points, other issues. My lord, I have been working for last 27 years
Where
as
is
a
the stay
casual in
petition?
Damodar Valley Corporation.
Where is the stay petition?
No statement is required. Only memorandum.
Okay.
Only
The
memorandum.
unfortunate part of this, my lord, I was in the my lord, in the trial court, my lord, and my lord, before the learned judge, my lord, we came up with an application for recalling and modification. My lord, on that ground, my lord, well, if you are agreed by the order, you go to the appeal. Then, my lord, why there is the provision for recalling? My lord, we are slapped on, my lord, to be 3,000 as cost, my lord. Kindly have a look at it, 3,050. My lord, is an insult to the injury, my lord.
You are not hearing us, sir.
Yes.
You wanted recall of the order dated 28/11. This paper does not contain that order. How do we know which order we wanted to recall?
Both order have been given, my lord. I was called by the SR department, and I have given that.
Where is that order?
I have given that order also.
There is the
order dated 28.
No, the memorandum of appeal has not come. This is only the synopsis and that list of date one. The memorandum of appeal must be there.
Second file দিয়েছে হয়তো ওটা যে দরকার পড়ে এখন কি জানি না ওটাকে
Wait, is there?
No, memorandum is here.
There.
Sir, memo of appeal synopsis is there. Memo of appeal is there. But the order, only the impugned order is available.
My lord, see, I have submitted. They called me from the SR section.
The application was filed, so didn't annex it.
What is
requiring that order? I submitted that order also.
The same is being submitted, filed here. Then you ask the department to put up that order.
আছে কপি আছে 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 দাও না দুটো কোনটা কোন এই যে এটা ইনপুট অর্ডারটা
Not at the read petition.
আছে
28/11/2023 order they want to recall. That order copy is not here. Department said file it. They filed it on 27. You put up that man. Are you carrying a copy?
My lord, it is mutilated.
Doesn't matter.
Yes, please.
একটা কপি রাখলে আর আছে
Actually, I submitted that copy. Well, I will finish these points very briefly. It starts from the petitioner claims to be engaged on some days of a month, and he continues to be engaged as such. This was the first observation. That is totally wrong, because when I submitted the records, Honorable Justice just ridiculed on me and criticized in open court. He told me, oh, very sleeky and very fine. he did not bother to see
No,
within
have
5 minutes.
have you
This
filed-
records contains my continuous service bank payment every month for last 20 years.
But should you not file that record before us?
So that records will be called from the mandamus section. I think so.
No. See, you can file an application, CAN application. Along with that, you put the enclosures. Have you seen the latest judgment of Supreme Court? No. After Uma Devi 3,
yes.
Last month there is a decision.
Sripal, Umadevi is the last month's decision.
After Uma Devi,
Hmm.
there is a recent decision of Supreme Court. You do some research.
What about that, my lord?
What about that?
You are referring to me, the judgment?
You search. You ask your junior to search.
No, I personally search it.
All right. What was the error you pointed out in CAN 1?
Yes. In CAN 1, my lord, there was
nothing is on record, sir. That's what we are trying. I don't know whether I am not clear, making myself clear, or you are not able to understand.
My lord,
Whatever you are referring to, those documents, nothing. We have got only this. Should you not file something?
my lord, we are told, my lord, when the matter is taken, my lord, the trial court records, my lord, are called for, my lord, before giving, my lord.
We'll call for the trial court records, sir. Where is Mr. Ranjay De? You have to ensure that the respondent is present.
So we'll give them notice.
In the meantime, you search that judgment also. The appeal, this appeal, intra-court appeal has been filed challenging the order
12 July.
dated 12th July 2024. By which CAN 1, no, sorry, order dated 28th November 2023 dismissing the writ petition, and also the order dated 12th July 2024 dismissing the application filed for recalling the order. The copy of the order dated 28/12/2023 is not on record. It appears that on 27 September 2024, the appellant counsel has filed the same in the department. The department is directed to put up the copy of the said order. The what is it? Writ file. What should be called for?
Have the petition. Writ petition.
The writ petition. But writ petition is called for, there will be only one set.
My lord, we'll make arrangement another two sets.
It is better you file.
Yes, my lord, only thing is there is no stay petition. That's why, my lord, what we understand.
No, we will give you liberty.
Yes,
the learned advocate for the appellant is directed to file a compilation containing all documents and details which were filed in the writ petition.
My lord.
Let copy of the same be served on the counsel appearing for the respondent Damodar Valley Corporation. List the matter after 2 weeks under the same caption.
But the problem has arisen because there is no stay petition. When we file the stay petition, we give all the records of the trial court. That is the difficulty, my lord. We are made to understand, my lord, the records will be called for.
Thank you.
My lord, we will come up with as directed. My lord, our anguish is this. We came up, we tried to avoid the appeal court, my lord, to lessen the burden. My lord, since there is a provision for recalling or modification of their review, we came up. My lord, we are told bluntly, you see, if you are agreed by the order of the trial court, you go to the appeal. My lord, then, my lord, we are slapped with rupees 3,500.
All right, sir, take down. In the meantime, the direction imposing cost of rupees 3,500 shall remain stayed.
Grateful, my lord.
My lord, this is an insult to the injury, my lord. My lord, there is a provision.
You make submission on merits.
No, my lord, we are summarily.
Please.
My lord, we are shown the door, my lord.
Number 10, 11.
Discussion with regard to item number 10 I'm appearing on behalf of the appellant in item number 10, and 11 I'm appearing on behalf of respondent number 1, Lordship. Both the appeals have been filed challenging the same order, Lordship. In both the matters, I'm praying for a week's adjournment, Lordship. I have already informed the learned advocate appearing on behalf of the other side, Lordship.
Paper books are ready?
Yes, it is ready, Lordship.
All right. The appeals are to be heard, and the learned advocate appearing for the appellant in MAT 1380
Lordship.
of 2024 seeks accommodation. Give a date on 3rd week of July.
Lordship, let the matter be remain in the list and let it be
Difficult, madam. Difficult.
next Monday,
If it is
Lordship.
possible, definitely. We can't end.
Let the matter run in the list,
But
Lordship.
Deeptesh, why it is coming under the admission? If the paper books have been filed, it should be under the hearing. List as under the caption for hearing. Next,
Lordship, it is made returnable on.
we'll give a date. Please wait.
Serial number 12, 13.
Lord, in respondent, my lord, item number 13 is concerned. I am appearing on behalf of the respondent writ petitioner.
My lord, I am appearing for the appellant in item number 12. I am led by
Respondent writ petitioner. This is state's appeal, my lord. তুমি স্টেটের হয়ে করছো নাকি একটু বললো বলছো
You are appearing for WPDC.
No.
No, my lord.
He is appearing on behalf of the respondent in item number 12, respondent writ petitioner. I am appearing on behalf of the respondent writ petitioner in item number 13.
Who appeals for the appellant?
Mr. Tonoy Chakraborty.
Last occasion also
Yes.
somebody sought adjournment.
And if your lordship go through the records, your lordship will see repeated accommodation has been prayed for on the behalf of the state for.
All right. And both the appeals have been filed by the state.
Yes.
None appears for the appellant, dismissed for non-prosecution.
Lordship.
On the last occasion also, adjournment was sought for, and the matter could not be heard. On the previous occasion, that is on 5/3/2025 also, none appeared for the appellant. Thus, it appears that the appellants are not interested in prosecuting the matter. Dismissed for non-prosecution. Next.
Serial number 14.
14, Your Lordship, I appear for the Union of India.
Have you got any instruction on the appeal petition which was filed?
Yes, Your Lordship. So, Lordship, the candidate who has preferred this appeal, he had appeared before the recruitment board on 28th of October 2024.
Yes.
Now, the recruitment board carried out his physical standard test, wherein he was declared not qualified in height, not qualified in chest, and this was observed at the time of measurement. Therefore, the learned single judge was pleased to dismiss the writ petition because he did not qualify on merit. Now, the required standard of height is 170 centimeter, but the petitioner's height was measured at 169.7. Now, there's no provision for rounding off. Besides the above, the required standard of chest is 80 to 85, expandable. But the petitioner's chest was measured as 78 to 85. So that...
Correct. We noted that.
Yes,
and
Your Lordship.
we asked you to get instruction.
Yes.
Whether the appeal petition was taken on file. According to him, remeasurement, your regulations or something provides for appeal remedy.
Right.
He has preferred an appeal.
Right.
And sent it through email on 1st of November. Any instructions on that appeal?
Your Lordship, with respect to that, they have not provided me with any specific instructions.
That was the direction, madam.
Yes, Your Lordship. But when I asked them, they said that he is not even eligible to be
Maybe
considered.
let them say so. But if he has got a right of appeal, he has exercised it. If he has not exercised it, he
Yes.
may be right. But according to him, he filed the appeal on 1st of November and the
Right.
same was sent through email on the very same day.
Yes.
Right.
Where is the
Page 50. Page 50 and 51.
We can do one thing.
Yes, Your Lordship.
We will ask him to enclose this
Mhm.
appeal copy along with a copy of our order, which we propose to pass today, and we'll send it to the appellate authority. Let him pass us speaking.
Much obliged, Your Lordship. That will serve the purpose.
I'm grateful to Your Lordship. I'm grateful.
This intra-court appeal by the unsuccessful writ petitioner is directed against the order dated 11th February 2025, by which the writ petition was dismissed on the ground that the physical standards which are required to be met by a candidate who participates in the recruitment in the paramilitary forces cannot be relaxed. On the finding rendered by the learned single bench cannot be faulted, since the court is not expected to interfere with the physical standards which are required for uniformed services, and it is for the recruiting authority to fix those standards. However, it appears that in the order of rejection of the writ petitioner's candidature dated 28th October 2024, it has been stated that if a person is not satisfied with the ground of rejection during PST, he may prefer an appeal to the appellate authority. According to the appellant, an appeal was preferred before the appellate authority on 1st November 2024, and the same was sent through email on the very same day. Copy of the said appeal petition has been enclosed in page 50 of the stay petition, and copy of the and screenshot of the email sent to the authorities has been annexed in pages 51 to 52. Since the order of rejection itself states that a candidate who's not satisfied with the ground of rejection during PST may prefer appeal in writing to the appellate authority, through the presiding officer, we are of the view that the appeal remedy availed by the appellant should be considered.
No appeal was preferred.
It is seen from the appeal petition dated 1/11/2024. It is addressed to the Director General, CRPF within brackets Recruitment Branch, New Delhi. Copy marked to CRPF Durgapur Group Center, CRPF Group Durgapur. It is now, however, the order of rejection says that the appeal should be preferred on the same day through the presiding officer. In any event, since there is prima facie proof to show that the appeal was sent through email, without standing on technicalities, we are of the view that the appellate authority can consider the appeal on merits and in accordance with law. In order to facilitate the said process, the appellant is directed to file a fresh appeal petition enclosing copy of the earlier appeal petition along with copies of the screenshots of the email and a copy of this order, and submit the same. Who's the appellate authority?
The Director General, the addressing respondent number. The 6, respondent number 6.
And submit the same before the respondent number 6 by sending the appeal petition along with annexures through speed post with acknowledgement. Within 2 weeks from the date of receipt of the server copy of the said appellate authority / competent authority shall consider the appeal petition and pass orders on merits in accordance with law within a period of 2 months from the date on which the petition is received. It is made clear that this court has not gone into the merits of the matter. However, also taken note of the fact that the appeal was not presented through the presiding officer. Nonetheless, since the matter was before court, the above direction has been issued. However, it is made clear that this direction shall not be treated as a precedent.
May I pray for one thing, if the appellant succeed in the appeal, the consequential steps may be taken.
Difficult.
This is the one part.
Chest measurement you can't do it.
If the appellant
chest measurement, let him get himself physically fit. What's the noise? Dismissed.
Next
Unless you
two
file
hurdle, next two
Last
hurdles
one,
should be crossed.
You file application, we will impose cost and then restore.
Kindly, my lord. I have been appearing in this issue, pending
Grateful
for
to you.
Supreme Court. My lord, on that ground itself, the other court was adjourning the matter. My lord, to see the orders.
All right. You inform the councils.
My lord, actually, my lord, I have been told Mr. Bikash Ranjan Bhattacharya will be appearing and they'll be praying. They'll be praying. They'll be. Oh, someone. They'll be taking time. That's why I was late, my lord. I was told this. They'll be taking time.
No, WBSCL, they were appearing.
The
What is
transport company.
What is their name? Chatterjee, some Chatterjee. She was
Correct.
appearing on
My
that.
lord.
All right. Let it remain in the list. Don't we dismiss for default, no? Don't type that out.
12 and 30. I'm grateful, my lord.
We'll stop with this, sir. I got a meeting to attend.
Each of the time we will.